Hello, everybody. Okay, so I'm going to wait for some people to get in here before we start. But do we have a show for today? I was not going to go live today, but there is just so much going on in these cases, you guys. So don't be afraid there. Please smash that like button on your way in. Let everybody know that we are live so we can get going. Hello, Bruiser Brody. Hello and welcome. Welcome, everybody. So a lot of new information has come out, you guys, in these cases, especially with the Chad Daybell and Lori Vallow case. There's some new documents that were just filed in the Brian Koberger case. There's stuff with the Savannah Soto, Matthew Guerra case. The Summer Wells case, the Richards Allen case. It's just gone crazy. Thank you, you guys, for smashing that like button. TK Sass, good morning. Nana, good morning. So I want to welcome everybody coming in. Charlotte. Hello. Catherine, hello. From Australia, welcome. Lots of stuff we got to go over, you guys. Like, this is becoming a crap show. Just like this is why, you guys, I made that one hoodie in my store. Welcome to the shit show. It's the trial coverage section on my Bonfire store. It's like, and this is one of the best reasons why here. So let's get into this, you guys. I'm going to present a bunch of stuff here. Okay, new filings. I don't know who has seen what, so we're just going to go over it. John Pryor in the Chad Daybell case. He is scheduled to go to trial. His trial is supposed to start April 1st, which is only a couple of months away, you guys. Now, all of a sudden, remember when I said when John Pryor had filed to squash the death penalty in Chad's case? And I said, watch the commotion and everything that's going to happen if this is denied. Well, the judge did deny it. The death penalty stands. So this is what's come out now. John Pryor filed a motion to seal. Okay. Nothing really. It's happened before. But what is it? Comes now the above named defendant, Chad Guy Daybell, by and through his attorney of record, John Pryor, and pursuant to ICAR 32I, subsection 1 and 2, and moves this court for an order sealing the motion to withdraw as counsel and declaration of counsel in support of motion to withdraw. The information in the pleading is sensitive to Mr. Daybell's right to a fair trial, and the information may be prejudicial to Mr. Daybell. I, trying to find unbiased jurors who would not be biased by Mr. Daybell seeking court-appointed counsel in this matter. The information is therefore information that is private and privileged. Like, what is going on with the justice system? Is this the new justice system, you guys? Let's seal everything. Nobody can know anything. Well, wait and see what happens, what the judge does with this. The information is necessary to the court in order for the court to make a determination of the merits of the motion to withdraw. Defendant and his counsel request that the information be filed under seal so as to not violate the court's order regarding discovery disclosure. That's not discovery. until such time the court determines the information may be made public. Well, the judge made an order, okay? So John Pryor filed it under seal. He doesn't want the public knowing what he's doing and why, okay? We're going to go over this because there's stuff that a lot of people don't know about this thing between Chad Daybell and John Pryor, okay? Shelbell, hello. Okay, so the judge decides on January 11th, the court received a request from the defendant, Chad Guy Daybell, to file a motion to withdraw as counsel under seal and permitted the motion to be temporarily sealed for further review. Well, there was no hearing or nothing, but the judge has decided the court has reviewed the motion to seal and a declaration of counsel in support of a motion to seal, which we're going to read, and the underlying motion to withdraw, which we're going to read, as counsel. In the interest of judicial efficiency and the fair administration of justice, the court enters the following order. Pursuant to Idaho Court Administrative Rule 32, the court has determined that the motion to seal is not recognized as an exempt record under ICAR 32, subsection G. Further, in reviewing the request to seal and underlying motion to withdraw as counsel, the court finds that the interest in public disclosure predominates over any claimed privacy interest in the filed proceedings. Like John Pryor, you have been paid for a few years now by whoever, whether it be Chad Daybell, partially Chad Daybell, partially, the people of the state. They have a right to know what's going on. As such, the court directs the court clerk to file the motion to seal, the motion to withdraw as counsel, and the declaration of counsel in support of the motion to seal to the record and publish the documents. Okay, so, and then the court will call the motion to withdraw as counsel for public hearing. So I will be streaming this, you guys, on January 18th at 10 a.m., which is noon Eastern. Okay, so I will be covering that. So you can watch it here. So here is what John Pryor filed. Declaration of counsel in support of motion to withdraw. Okay, because we're going to see his motion to withdraw right here. John Pryor, being first duly sworn, deposes and states as follows. I'm currently counsel for Chad Guy Daybell in the above entitled matter. I have exercised due diligence in seeking a capital qualified attorney that could serve as co-counsel on this case, but none have been available. Now we know in Idaho, you got the Brian Koberger thing going on. We got the Chad Daybell thing going on. What else do we have going on? A few things going on in Idaho on major cases where there's no more death qualified attorneys. I don't believe that for a second. And John Pryor is not death penalty qualified. Now, he has known this for a long time, since the very beginning. He knew that they were going to be seeking the death penalty. The death penalty request and filing was made by the prosecution a long time ago. Okay? So, he has known about this for a long time. As a result, I have acted as sole counsel on all aspects of representing Mr. Daybell in this case and have fully expended the retainer of this case in providing representation to Mr. Daybell. What? Did you blow through the $500,000 life insurance policy that Chad had on Tammy already? I don't know why some of the pages are like this, but anyway, after speaking with Mr. Daybell, I have confirmed that he is unable to pay any additional funds, and he believes it would be a disservice for me to continue to represent him in a capital case and trial without compensation. Well, wait a minute. Let's talk about that. Because John Pryor owns Chad Daybell's house. So not only did Chad Daybell have I don't know what the property value would be for that out in Idaho, but I'm sure it's quite a bit with the amount of land and everything else he has. So John Pryor has Chad Daybell, now owns Daybell's house and property, and he has for some time. Plus, there was the life insurance policy that Chad Daybell got, all that money. Yes, we're going over it all. We are going over it all. And hello, Alley Cat. I haven't seen you in a while, so welcome back. He further seeks the appointment of 2 capital qualified attorneys to represent him in this matter. What does that mean? This means that the judge allows John Pryor to bail, this case is not going to trial on April 1st. We're going to be lucky if it goes to trial before 2025, 2026, right? Thank God these trials were separated, because Lori would have walked. Oh. Without compensation, he owns his house. And I don't know how much money Chad has squirreled away for from that life insurance policy before it was found that he took Tammy's life. He further seeks the appointment of 2. Okay, we read. I convinced an attorney from Boise area to petition to become capital qualified. However, that process, even after a significant amount of time, has not been approved by the Public Defense Commission. The time to have meaningful assistance by co-counsel has long passed. You've known this for a long time. At the present time, even assuming I work 24 hours a day, 7 days a week, could not complete all the tasks necessary to represent Mr. Daybell in this matter. He's had a couple of years to get his crap together. It's no secret or surprise that the Public Defense Commission lacks the necessity number of capital qualified attorneys in this case to effectively represent all the needs of this state. Therefore, with the consent of and the request by Mr. Daybell for other counsel, I hereby request to withdraw from this matter. Is the judge going to allow this? I don't know, you guys. What do you guys think? Let me know. Live chat for you guys watching this replay crew. Let me know in the comments below. What do you think the judge is going to do? I think the judge is going to have a hard time releasing John Pryor from this case, because it would just take too much. Like, everything he's done is out the window, and new lawyers would have to come in and start again from day one. I can't see the judge allowing this. Now, what I can see the judge doing is saying, okay, well, the state's going to take over paying your fees because he's now indigent, which means he has no more money. And the courts appointing a lawyer who is death penalty qualified. That's what I can see the judge doing. As provided by Idaho Code Section 9-1406, I declare under penalty of perjury, pursuant to the law of the state of Idaho, that the foregoing is true and correct to the best of my knowledge and belief. So it's like, okay, I've taken your house. I've taken every bit of money you've had. See you later. Out of here. No, I find there's problems with that. Not just with the amount of court time that has been assigned to this case and used in this case. Alley Cat, I don't think that's going to happen. I think that what the judge is going to do is appoint a death penalty qualified attorney to assist. John Pryor will have to take second seat. But I do not believe that he is going to just let, after, you got to think of this, all that court time, the money invested even on the state side, to have to now argue motions and discovery and everything else all over again with new lawyers. I don't think it's going to happen. What I think is going to happen, and I'm going to say it now, and this is just my opinion, is I believe the judge is going to order that the state start paying John Pryor. I'm going to say that he's going to vacate the trial date of April 1st, and he's going to give time for another lawyer who is going to be probably appointed by the courts as for a death penalty qualified attorney to assist. Not to assist, actually, to take basically this over. And they're going to vacate the April 1st court trial date because to bring this death penalty qualified lawyer up to speed. And he is going to take first seat. John Pryor is going to take second, which John Pryor is not going to like. That's what I think he is going to do. No, he can still be on the case taking second seat. But he would have to have a death penalty qualified attorney to take first seat, which means he's the one that's calling the shots now, not John Pryor. And John Pryor is not going to like that. So this is what I think personally, you guys, is what's going to happen in this case. Okay? Okay. So this is his motion that he filed. Motion to withdraw as counsel. Pursuant to ICR 44.1, undersigned counsel hereby moves to withdraw as counsel from this case. Since May 25th, 2021, undersigned counsel has represented Mr. Daybell. So almost 3 years. In this case and the related previous case under cause number, it should be case number. Okay, prior to that time. In that time, undersigned counsel has undertaken as sole counsel all matters of representation, including obtaining and reviewing discovery, conducting investigation, and hiring and working with numerous experts. Can you imagine, you guys, if they have to do this all over again and pay for the state to pay for lawyers to go over this all again? He's asking for 2 death penalty qualified lawyers. I don't think the judge is going to let that fly. I think the judge is going to keep John Pryor on the case. The state's going to start paying John Pryor, and they will appoint a death penalty qualified lawyer to the case who is going to have first seat. But they're not going to want to have to pay for all this to be done again. If the judge takes Pryor off the case, okay, all of this would have to be done all over again, and the state is not going to want to pay for that. Mr. Daybell retained undersigned counsel with personal funds, being his house. John Pryor now owns his house and has since he took on the case. That was, I guess, one of the deals. Plus, Chad Daybell had almost $500,000 in life insurance money, right? At a hearing on January 19, 2023, this court inquired of Mr. Daybell and declared him indigent. Pursuant to IC 19851, Mr. Daybell does not have the ability to pay for counsel's continued services, and Mr. Daybell seeks the appointment of 2 capital qualified attorneys to represent him. Well, what he wants and what he's going to get and what he is entitled to is a lot of different scenarios. Okay? Smiling is contagious. Hello, hello. Says, thank you, Willow. I did not know that, but I sure hope they go with what you think. I do think that's what's going to happen. He should have used that money to fix his chin. Like, so now he is out of all that money. He's lost his house to John Pryor. So at a hearing on January 19th, you've known that he's indigent. Well, what's been going on for a year? You've been on this case for a year. What's happened is they filed a motion to remove the death penalty, and that did not happen. And this is why John Pryor is doing this now. He's hoping that they will say, okay, look, stay on the case and we'll remove the death penalty. That's what he's hoping. That's just my opinion, you guys. But that, I told you, the shit show was going to start happening as soon as they denied the death penalty being removed. So he wants 2 capital qualified attorneys. Well, what he wants and what he gets, he needs at least 1. So I do believe that the judge is going to keep John Pryor on the case. The state is going to continue is now going to pay John Pryor, and they will appoint a capital qualified attorney to sit in first seat. John Pryor is going to have to take second seat, and that's what he don't want. He wants to be number 1. So as this court is aware, this case is both extraordinarily complex, and the prosecution is seeking the death penalty, which requires counsel to essentially prepare for 2 trials. The defendant's motion to continue the trial date to enforce Mr. Daybell's constitutional rights. So he's also filed a motion to continue the trial date. We have not, that's not in the record yet. So that will be coming. There's going to be a motion to continue the trial date. I just seen that there now. Reflecting the complexity of the work required to prepare and try this case, this court has set aside 2 full months for trial, and the prosecution team consists of no less than 5 attorneys from 2 county offices, including an out-of-state attorney hired at taxpayer expense. Remaining on this case were required undersigned counsel to work around the clock more than full time. You should have had help from the time you took this case. He didn't. Okay? You've had 2 years to be working on this case. You should have hired help. That's not the court's fault that you did not hire the help for more than 4 months without compensation and without the assistance of any other counsel. That is his fault. He decided he wanted to look like Superman. I can do this by myself. Nobody does that on a capital murder case like this. Death penalty case, sorry. You should have asked for the assistance of other counsel. You should have got that 2 years ago. And a year ago when or just over a year ago when the prosecution put this as a death penalty case, you should have got help then, not waited until 2 months before the trial. The judge is not going to be happy. This motion is made with Mr. Daybell's full consent. Mr. Daybell has requested from me that he be given 2 capital qualified attorneys for his trial. I have made a diligent effort to find a lawyer to assist in this matter for a significant amount of time. The attorney who I located and agreed to try and get qualified has not yet been approved by the Public Defense Commission. The time for him to be of any assistance to me in preparing for this trial is long gone. Yes, because you should have got this done long ago. Long ago. And if you couldn't do it on your own, you should have asked for court's assistance. Because Mr. Daybell is facing the death penalty and has been determined indigent, he is statutorily entitled to appointment of 2 counsel who are capital qualified at state expense, stating that 2 qualified trial attorneys must be appointed to represent an indigent defendant in any case in which death penalty may be imposed. The Idaho State Public Defense Commission maintains a roster of capital qualified attorneys, while undersigned counsel would accept appointments to this case if it were on non-capital. Because Mr. Daybell is facing the death penalty, undersigned counsel cannot be appointed pursuant to the statute. The counsel therefore moves to withdraw. Notice is hereby given that on the 30th day of January 2024 at the hour of 9:30 a.m. or as soon thereafter as counsel may be heard, John Pryor, attorney for the defendant above named, will call up for a hearing for the defendant's motion to continue before the Honorable Judge Stephen Boyce. So let's mark that down. That's probably going to be done on the same time. All these, he was already scheduled for a hearing at the end of the month anyway, so I'm assuming this is just going to be added to it, because we do have a notice of hearing right here for the 18th. So there's going to be a hearing on the 18th. I am going to be covering it. So if you want to see that and hear what's going on, the court has not sealed it against what John Pryor wanted. He has not sealed it. Smiling is contagious, says Willow. Do you wonder if John is realizing there's no way to beat it and just wants out? I betcha. I betcha. The judge can deny it. The judge can order that he stay on the case and appoint a death qualified attorney, and that the state will now start paying his legal fees. But if he said in here, where did it say? Hang on a sec. Let me just find it here. Okay, let me just find where he says this, you guys. I forget which one it's in. Hang on. Where the heck did it go? I think it's in here. Hang on. Okay, so here it is here. Since May 25th, 2021, undersigned counsel is represented. Okay, wait, blah. Okay, here. Okay, here. Mr. Daybell retained undersigned counsel with personal funds. At a hearing on January 19th, so a year ago, this court inquired of Mr. Daybell and declared him indigent. So, for a year now, he has been declared indigent. So why haven't they done something in this last year to start covering John Pryor's fees, right? Because for a year now, he has been declared indigent and does not have the ability to pay for counsel. So why did you wait a year then, John Pryor, to 2 months before the trial before filing to be removed? Why didn't you do that a year ago if he had no more money to pay you and he was indigent for a year now? You're saying it right here on January 19, 2023. We're January 2024. So you've known for a year that he's indigent. Why are you only doing this now? This is suspicious to me, you guys. Very, very suspicious. Also, Lori was supposed to go, her trial was supposed to start April 4th, 3 days after Chad Daybell's case started. She has a new case out there in Arizona where she has an attempt of taking somebody's life on Brandon Bordeaux and a conspiracy and first degree, I think, in the death of her then husband, Charles Vallow. Now that case has changed to pending. What does that mean? Her case is on hold now, and I believe it's because she's being sent for some kind of treatment yet again. So we have Lori, who's facing more charges in the death of Charles Vallow and the attempt on Brandon Bordeaux, which is her niece's husband, was her niece's husband. Her trial is now on hold and pending in that because I believe that she has been sent for treatment again, been, I don't know, incompetent again. I don't know. But it's now been put to pending, which generally that is what it means. that she's been sent for treatment or something along those lines. And we got this happening with Chad Daybell. Coincidence? I think not. I think not. Coincidence that for this last year, John Pryor has known that Chad has no more money, but he continued to represent him, including trying to have the death penalty squashed, taken off the table. I told you they were going to come up with something. I thought it was going to try and be a plea, but I think this is another way that John Pryor is trying to force the prosecution to remove the death penalty. Look at, you don't want to remove the death penalty. Guess what? Kick rocks. I'm gone. I'm out. See you later. Bye-bye. I've got his house. $500,000 from, insurance money. Took all that from him, and I've not done nothing. 2 months before trial, I'm out. See ya. That's not gonna fly. Right? So there's that. So another thing that I want to hit on before we get into a couple of other things here that I want to talk about with the Brian Koberger, there's new documents that are filed there also. We're going to go over that. I haven't really covered a lot of, let me just get my things open here. I haven't really covered a lot of the Richard Allen case with the Delphi. I did do reads on it, but that just got right whacked out. But what I do have a problem is with a few things here. Okay. I'm going to bring up this picture. I don't know if you guys can see it. No, you can't. Okay, so let me stop sharing the screen and hang on a sec, you guys. Let me get that out of there. Let me get this out of here. Okay, let me see. Let me bring this up now. And make sure you guys can see it. This is what I have a problem with. You see this? This is Richard Allen. See the handcuffs on him? Handcuffs, which are usually shackled. Look at the dirty shirt. Looks really unkept. This is how he is brought into court. Okay, why is my screen not showing? Hang on a sec, you guys. Let me fix this. Okay, let's see if we can do it this way. You see how he is brought into court? I just make this smaller so I can see, make sure it's showing up on screen. See how he's brought into court? Look at the chains around his waist to handcuffs. His feet are shackled. Okay, this is not doing what I want it to do. Hang on. Sorry, you guys. Bear with me. Okay, let's see if it'll come up now. Okay, there we go. You see that? Whoops. You see this? To me, this is inhumane. But, okay, so Richard Allen is, everybody knows, been charged with first degree in the deaths of Abby and Libby. Now, let me show you photos of how Chad Daybell comes to court. See any handcuffs on him? This is in the court. Here he is in the court again. See any handcuffs? Dressed in a nice suit and tie. This is somebody who is facing 3 first-degree charges, right? 2 first-degree charges, 3 first-degree charges. I want to see somebody who's facing 4 first-degree charges. This is Brian Kohlberger. This is how he's coming into court. See any handcuffs? See the nice suit? What's wrong with this picture? Richard Allen is being held in a prison while Chad Daybell and Brian Kohlberger, wearing their nice suits or shirts with ties, suits with ties, right? This is how they're treated. And they're in local jails being held. What happened to this? What happened to this? How did we get from that to this with Brian Kohlberger? And how did we get to this with Richard Allen? Okay, I'm not one to, jump at things like this, but I think that there's something very unfair with what's being projected here and how different people are treated differently. There's Sis. Hello, Sis. Alicia, hello, and welcome. Right? You see those different photos. How do we get to that? How did we get to this with Richard Allen? Look at the filth. How did we get to that? And how is that okay? It's not. Okay, so the next that we're going to go over, that's just something for you guys to think about. He's in a maximum security prison. You don't go to max security prisons until you're found guilty of something. He still has not got a trial yet. He is innocent until proven guilty, the same as Brian Kohlberger and Chad Daybell. That's why they're in jails. How is Richard Allen more of a threat that needs to be in a supermax than somebody like the likes of Brian Kohlberger or Chad Daybell, right? And with the Chad Daybell case, Chad's daughters are still living in that house. So I wonder what's going to happen. No, Allie, I haven't really been following it. It just got too much of a shit show for me that it just overwhelmed me with everything else that's going on. I know that the judge fired his lawyers or threw them off the case and all this stuff. And then they went after the judge, and it's become a shit show. Now, Alex Murdaugh may get a new trial because of what the clerk did in that. Oh my gosh. Like I'm asking, is this what justice is today? Is this how justice? I remember old day courts, and it's like the criminals are playing with the courts like monkeys in a circus. Okay, so let's go now let's get Savannah Soto, and then we're going to get to the Brian Koberger case. Savannah Soto, everybody must have been able to see that read by now. I did make it public. Okay. Let me get this up on the screen and I will share it with you guys. Okay, so let me just get this one over here. And let me get this one up. Sorry, you guys. I'm not good at all this technical stuff, so I'm doing my best. So please just bear with me. What happened? That's not what I wanted up there. Oh my gosh. Okay, hang on a sec, you guys. Okay. Okay. Let me show you this. Good morning, True Crime Time. Okay, here we go. Don't mind my writing on the bottom here, you guys. I don't like using anybody else's material. I use my own, so hence why you can see me trying my best here to write with my mouse. So this is the Romanos family. Christopher has been charged. Let me just see here. I want to get it right. Police have charged Christopher Ray. I'm not even going to try and say his last name. Preciado, 19 years old, with capital murder, abuse of a corpse, and alter or destroy a human corpse. His father, Ramos, this shouldn't be here, you guys, so sorry about that. Ramon Preciado, 53, was charged with alter or destroy human corpse and abuse of a corpse, and a charge for helping his son move the bodies after he took their life. And now we got the mother. Now, some people are saying that this is his actual mother. Some are saying it's his stepmother. I did see a marriage certificate for Mirda and Raman. So I do believe they're legally married. That was back in like 2008 or something. I seen a certificate of marriage. Anyway, she's 47. And she's been arrested and charged with 3 different charges, including alter, destroy, or conceal a human corpse, abuse of a corpse, and tampering with evidence. See, Shelby is saying stepmother. So I live in Houston area and still get chills about your reading on Savannah. Yeah, it's crazy. It's crazy. And I did that read on December 26th. It's right on the video. I can't change that. When you go live, it automatically underneath the video shows when you did that video. I can also pull it up and show it too. But anyway, I did that on December 26th. And I wanted to do an updated read because I wanted to know where the argument happened with this, why that fire came out. I knew it was a heated, aggressive argument. There was something about a knife too, so I don't know if that's going to come into play. That it was over money. There was a lot of things. The number 3, I had just done a live prior to doing the read on them. And in my live, I said, okay, I'm going to get off my live now so I can go and do this read. I did the read. 3 hours after I did that read, they were arrested. Christopher and Ramon were arrested, I believe. Or no, 3 hours after the read, their bodies were found. And then, so there's 1-3. And then January 3rd, these two were arrested. And then another 3, a third person was arrested. Like there was so many 3s, right? And I said, there's 3 people. So when they arrested Christopher and Ramon, and they said, no, we're not looking at arresting anybody else, blah, blah, blah. I said, oh, no, there's another one coming. I told you guys that right in my live. Okay, Nana, we'll be here. So the third arrest did come, and that's in the taking the life of Matthew, Savannah, and baby Fabian. Their drug life, their drug style, you know, like you're going in, and I'm not victim shaming, but this is the life they chose, right? And here you are getting ready to go in and be induced. Why are you even going out to do something like this the night before? Right? Why? Why would you do that? Why would you put your baby and yourself at risk? Right? So all 3 of them are going to be locked up, I think, for a while. Just going over my notes here. Now, let me just get rid of this because we've got more to go over in the Brian Koberger. I'm going to show you there's new filings right up until late last night. There's been another filing. So I'm going to go over that with you. Now, there's a way for me to give you guys free memberships. And I'm trying to find it. Let me just see here. I don't know. Do I click in here? Nope. I don't know how. I don't know how to do it. There's a way for me to gift memberships. And everything they said I had to do in my live, I can't do. Unless I got to click on somebody's name. Nope. I don't know. I don't know how to do it, you guys. I will try and figure it out. I had a lot of stuff that I had to deal with lately. So, okay. So what else? Oh, the Brian Koberger. Okay. So let's bring this up. Let me get rid of all the Chad Daybell stuff here, you guys. Okay. So what do we have here? We have been waiting for some time for the judge to make a ruling on the IGG. So this is a public order for disclosure of IGG information. Now, please listen to this whole thing before we start going nuts. Because you have to look at what is actually said by the judge here. I know with the FBI stuff, you guys, the FBI, it takes a lot. And 90%, no, I'm going to say 95% of the time, the courts don't get anything that they're trying to get from the FBI. The FBI can mute. Nope, you're not getting it. You're not getting it. You're not getting it. You're not getting it. That's our work product. You're not getting it. You're not getting it. And they have to jump through hoops. It could take a couple years for the judges to get stuff from the FBI. It's not like ordering local police to turn over something, or a lawyer to turn over something, or a witness to turn over something. That's not how it works when it comes with the FBI. Generally, I say, if the FBI don't want to give it, you're not going to get it. So, what has happened? I can guarantee you that the FBI has not turned over to the prosecution any work product, which means certain things that they are not going to disclose because it will alter or hurt any further investigations, and it's giving up their investigative tools that they use, which is not, as an FBI agent said, is not open for disclosure. They do a lot of things that people don't know about, and they're not about to give up their tricks and tips as to how they go about getting certain information. That would take away from their ability to gather information in a way that helps find a perpetrator. They're not going to give it up, and the court can't force them. They're the FBI, okay? You basically have to go through the Department of Justice and supreme beings to force the FBI to do anything that they do not want to do. Believe me when I say that. Okay, so what did they get? Public order for disclosure of IgG information. On October 25th, 2023, the court issued an order addressing IgG DNA, an order for in-camera review. In-camera review only means that the judge is going to look at it in private, in chambers. The only time that anybody else would be in there is if he needed an expert witness, and would have to be classified an expert witness because maybe he doesn't understand something in the documents or something along those lines. That's the only other time somebody else would be in there. But this is in private in his chambers. Why they say in-camera review, I don't know. Unless they do videotape him going through the documents without showing the actual documents. TK Sass says, have you or anyone else seen that another witness has come forward? In which case? We've talked about a lot of cases here. TK Sass, which case are you talking about? Miss Always Right Ryan, nice to see you, beautiful. And crime time. True crime time. No. Hang on a sec. I don't see anything that's verified, so I'm going to say that that's probably something else they're making up. So we're not going to talk about it unless I can verify it. We keep everything verified here. Our sidewalk cleaners are going by, so sorry for the noise. Just give me a second, you guys. Hey, sorry about that. It was not the sidewalk cleaners. It was my snow removal company coming to clear my driveway. Cool. It's all going to be ice now. So yeah, I haven't heard nothing about that TK SAS. So I'm going to say that it's more rumor, more fake news until I can see it. Unless you have a verified source that it came from, I wouldn't believe what you hear. But definitely, if you do have a source that it comes from that's verified, I would go over it. Okay, so let's get back to this. An order for in-camera review that addressed the state's motion to prevent the disclosure of investigative genetic genealogy, IgG, information to the defense, and the defense's motion to compel discovery of all information pertaining to the IgG investigation. Now, what I have also found is, whoops, get out of there. I got to go over here. Let me just pull this up again. Okay, here it is here. Okay, let me just scroll all the way down. There's so much in his case, you guys. Okay. There's a defendant's exhibit J. Okay. That the defense is talking about. I'll show you that as soon as we get through this. I will show you that. And it's funny that the court has ordered them to turn over all information pertaining, the state's motion to prevent the disclosure of the investigative IgG information to the defense and the defense's motion to compel discovery of all information pertaining to the IgG. There's something else that's been filed. Alleycat, I just went over that. The in-camera review just means that the judge is going to look at this in chambers privately. It's not going to be disclosed to anybody. He's going to take it in his chambers. The prosecution had to turn over this information that was ordered to be submitted for in-camera review. In-camera review just means that the judge is in his chambers alone and he sees things in private. Okay, so on November 30th, 2023, the state submitted to the court in camera all IgG information pertaining to the state's investigation from both the FBI and a private laboratory. Okay, so on November 30th, the state did submit to the court, which gave the judge in camera, which means in chambers, all IgG information pertaining to the state's investigation from both the FBI and a private laboratory. Okay, so the only thing that they can turn over is what they got from the FBI. It could be one piece of paper saying, we're not giving it to you. And that's what they would have handed to the judge. Any other investigations that they did personally, I believe they would have to turn over, that the prosecution did personally, or other police, LE, law enforcement, and private laboratories. There may be things that were done outside of the FBI that the FBI had no part of that they turned over. But I don't think the FBI gave much, okay? The court has now completed its review of the information provided by the state. So it's only what the state has provided, and orders the state to discover to the defense a portion of the IgG information. So the defense is not getting all of it. They are only going to get a portion. The specific material to be provided is set forth in a sealed order to protect the privacy of the IgG information, including individuals on the family tree. So, what does that mean? That means that the judge was handed whatever the FBI gave them, whatever the laboratories gave them, whatever, these places where they do family trees, 4 and me and 2 and you and all that place, those sites, whatever they gave to the prosecution is what the prosecution gave to the judge. Here, Your Honor, this is what we have. The FBI could have, like I said, gave them a piece of paper that said, we're not giving you nothing. And that's what they would have handed to the judge. We don't know what was given because everything is sealed. But I can guarantee you things that the FBI did to gain information and to track down information is not going to be turned over. They are not going to give anybody, how can I say this? They're not going to let out into the public their tools that they use to hunt people down. They're not going to do it. Because what does that do? That sets up everybody to be able to find ways to get around those tools. And I do not believe that the FBI has to be, it will be, or can be compelled to give up certain information. The FBI can say, no, you're not getting it. And I don't think there's really much the judge can do. He could apply to higher courts. He can apply to the Department of Justice. He can do a lot. But I'm telling you, it is very hard to get certain things from the FBI if the FBI does not want to give it to you. And I believe that their investigative tools are some of that. But we will have to see, right? But what they got was a portion of the IGG, which I believe is going to come from maybe 2 and 3 for you and me and all those sites there, Ancestry and .com and all that stuff. I believe that they did get, and the defense is going to receive a family tree of how they narrowed it down to find Kohberger's dad, right? How did they find Kohberger's dad to compare this DNA to, right? So I think that the family tree thing is going to be disclosed. And then I feel that they're going to have to disclose also what they did once they got that information. How they got that information, they're going to say, FBI said they ran it through CODIS, no hits. He was not in CODIS. That DNA profile that they got off of that knife sheath is not in CODIS. So whoever left that DNA there has not ever been processed for like having to give their DNA or something like that. So misdemeanors, you don't got to give your DNA and stuff like that, right? Anyway, so the FBI then submitted that DNA sample to the 2 and me and 3 and me and Ancestry and whatever they did with it. Submitted that DNA profile to these different companies to see if any of the markers matched, and then broke it down and broke it down and broke it down and got a tree as to like if one of his sisters ever put their DNA in there. You know what I mean? To try and find all their ancestors and stuff. I think that, I don't know how it works, but that's how I am doing it in my head. That's how they finally, okay, look at his DNA is really close and has the markers of these 2 females, Miss and Miss Kohberger here. Or maybe they're dads, like, I don't know how they do it. But then what they did is they now had something to go on from this IGG. So did they say, okay, we got our guy now, this is him? No, they still have their profile from that knife sheath. Okay. It's a profile now with markers. It's a profile. So what they did was they were now looking at Kohberger's. So what they did is they followed Kohlberger or went to Pennsylvania, whatever they did, and they grabbed the trash. When they got something out of the trash and got DNA off of the trash and matched that, it lined it up beside the profile that they had from the knife sheath, and they got a profile from the trash that told them the profile from the trash kind of impartially it matched, and it told them that whoever left the DNA on the knife sheath, because of that profile, the markers say that this is a male offspring of, I think his name's Michael Kohlberger, is a male offspring. Right? So then when they watch the house and everything, and they see Kohlberger going and putting his garbage in the neighbors. And that's where they got another profile, right? That matched this profile that they got from the knife sheath. So regardless of what was done in 23andMe and 2andMe and you and me and Ancestor and me, it doesn't really even matter anymore, because now they have a profile from the knife sheath matched to a profile from Brian Kohlberger's family's garbage. So when they arrest Brian Kohlberger, they take a buccal swab from inside Brian's mouth and they get a profile. They enter that in, they get a profile which matches the profile from the knife sheath. You can't deny it. Now, what the defense is fighting is how they went about getting that. But what they compared the knife sheath profile and they compared Brian Kohlberger's profile, they matched. So it's not like they don't have Brian Kohlberger's profile or they don't have his dad's profile and they're saying, well, it's somebody in that family. They're not doing that. They're saying this is 100% match between Brian Kohlberger's profile and the profile from the sheath. What they're fighting is how they got there. And to me, I don't care how they got there anymore. All I care now is that they have Brian Kohlberger's profile from a buccal swab taken from Brian Kohlberger that matches the profile that was found on that knife sheath. Right? So, okay, so we got this. Let's put this over here. So now we have this. When was this? Okay, so this was filed before the judge's order. The judge's order was filed on the 11th of January, but on the 9th of January, so long before this information came out, sorry, you guys, long before Ann Taylor knew that the judge made an order regarding the IGG, she filed a stipulated motion to file Exhibit J attached to the defendant's 11th supplemental request for discovery under seal. Comes now Brian C. Kohlberger by and through his attorney, Ann C. Taylor, public defender, and hereby moves the court for an order to file Exhibit J of defendant's 11th supplemental request for discovery under seal. This motion is made. Okay, so the reason they want it sealed is it's pursuant to ICAR 32, and because, one, the document contains facts or statements that might threaten or endanger the life or safety of individuals, and two, it is necessary to preserve the right of fair trial, and disclosure would constitute an unwarranted invasion of personal privacy. What is this now? So they're making another supplemental. When you see supplemental request, they're saying, okay, well, we've got discovery, but we want a supplemental request entered because we want the court for an order to file Exhibit J of the defendants. They want to add something to their 11th supplemental request for discovery. That was done under seal. So now they've come up with something else that they found, and they want to add Exhibit J to this supplemental request for discovery. Now, a lot of people are saying, how come they have to keep asking, huh? This is just housekeeping, you guys. Every month, the defense is going to file for discovery. And why they do that is in case the prosecution may have overlooked something that's discoverable or has found something else that is discoverable, they want it. They're making it known every month. If you found anything new, we want it. Anything else, we want it. If you've come across something that you may not have sent us an error, we want it. That is just them keeping it on record that they are continuing want discovery. No matter how it's come in, when it's come in, whatever. They want it. That is just to keep a little tab in the judge's brain up there that we are still requesting discovery. This keeps it relevant. It keeps it that in case anything else has popped up or they found something they forgot, well, they didn't ask for it, so we're not going to give it to it. No, they're asking for anything that they may have come across or anything new that they have not sent over to the defense yet. That's why this is. It's not that the prosecution is continually not following orders for discovery. It is to keep the discovery requests relevant and up to date. So there's an exhibit that they want to attach to the 11th supplemental request. Supplemental requests are, we know you've turned over everything. You said you've turned over everything, but just, take a second look, or as if there anything new, please give that to us. Right? Hello, Leslie. Elma. Hello. So that is something else. Let me see if there's anything else here. What's this? January 5th. Motion to temporary. Okay, let me put this one up. This one here is a motion to temporarily seal objection to defendant's motion to reconsider orders denying motions to dismiss indictment, and in the alternate for permission to appeal from interlocutory orders and stay of proceedings prior pending hearing. So they want to stay, and they want to now seal, have the objections from the prosecution sealed, because they're saying that the release or disclosure would interfere with enforcement proceedings, deprive a person of a right to a fair trial or impartial adjudication, constitute an unwarranted invasion of personal privacy, disclose the identity of confidential source, and or disclose investigative techniques and procedures. And so we are going to hear about this, you guys, on the 26th. And I will be covering this also. I will be streaming the court case live on the 26th. So the new one that is coming is from the Chad Daybell case. I will be streaming that. I will be streaming, I'm just marking this all down, the Brian Koberger court hearing in the afternoon on the 26th. We are not allowed to see the morning session, but we will see the afternoon session. And Chad Daybell has motions hearings that are supposed to be happening on the 30th also. But that date was set before John Pryor decided that he wants to be taken off the case. So I don't know if that one is still going to go through, or if these issues are going to be taken up on the 18th or not. We'll have to wait and see. Let me just stop sharing now. We will have to wait and see. I do believe that as far as John Pryor leaving the case, being taken off the case, I don't think it's going to happen. I think the state is going to step in and start paying him. And I do believe the state will appoint a death penalty certified attorney to work alongside of John Pryor. But the death penalty certified lawyer is going to have first seat. John Pryor is going to have to take a back seat to him. And that's why I think John Pryor just wants right off of it. I think John Pryor threw a hissy fit and said, I'm not taking second seat to nobody. I've worked on this since the beginning. I'm anxious to hear all the arguments that he comes up. He's just saying that Chad Daybell has no more money. Well, if Chad Daybell was considered indigent a year ago, why did it take you a year to ask to be removed from the case? Because now you just wasted a year of court time and a year of things being able to be put together to go ahead, because he's scheduled for trial on April 1st. It's crazy, you guys. Leslie says the state will pay him. I believe they will too. I don't think John Pryor is going to get thrown off the case, but I do believe that there's an ethics committee, right? When it comes to lawyers, we got the Canadian Bar Association. I'm sure you guys got something equal in the United States. You can't just take somebody's house and all their money and then say, okay, toodaloo, I'm out. See you later. After 2 years of taking their house, John Pryor owns Chad Daybell's house and property, which means what happens now? Like, is he going to want to sell that house, kick everybody out because the daughters still apparently live there? He took in all his money, every cent he's had, and now like hasn't even gotten to trial yet. And it's like, toodaloo, kick rocks, see you later. I'm out. Adios, deuces. And I don't think that's going to fly. So we'll have to wait and see what happens with these cases, you guys. I'm going to wrap it up. We've already been here for over an hour. But like I said, I will be streaming on the 18th, this coming Thursday, this hearing about John Pryor. So make sure you're subscribed. Come and watch it right here. We will be having it. It will be noon Eastern. So I will have the thumbnail up probably the night before, so you guys can hit that notify me button. So when we go live, but I will be going live probably around 11:30 in the morning Eastern. So we can have a little bit of a chit chat and let everybody get in, and we will be watching this hearing. I want to see John Pryor face go red again. But I don't think that the judge is going to say like, adios, see you later. Okay, next. After you just took all this guy's money, wasted all this court's time, because putting new lawyers on, they're going to have to go over all of this stuff again and waste more court's time. So I don't know. I don't think it's going to happen, you guys. I think the state's going to step in and say, we're paying you. You're staying on the case, and we're going to appoint a death qualified, or maybe even two death qualified. We know what Lori Vallow, the death penalty was taken off the table, but she did have two lawyers. One was death penalty. I think they both were death penalty qualified, but you only need one. And the death penalty qualified lawyer takes first seat. And that's what I think John Pryor is having the issue with. He doesn't want to take second seat to anybody. That's why I believe he was trying to get the death penalty taken off the table so he could remain on this. But if that's the case, why were you doing that? Why'd you have that big to do? If you're not getting paid, why didn't you say something a year ago when he was classified indigent? Why have you waited a year to 2 months before the trial? You know what I mean? So I think the judge is not going to be happy. But we'll get to see it all right here. Tuesday, I will be going live. Not Tuesday. Thursday, the 18th of January, we will be going live 11:30 a.m. Eastern. And we will see what John Pryor has to say for himself. What the judge decides to do in this case, we will have to wait and see. But I do believe that he will keep John Pryor on, and he will appoint death penalty certified lawyer or lawyers to take first seat. TK Sass says, have you heard anything new on the Suzanne Morphew case lately? No. And I do believe they are keeping everything hush hush and rebuilding their case against Barry Morphew. We will not hear nothing until he's arrested. So, Showbell, thank you for being here. I appreciate you guys. You're awesome too. You guys are awesome too. So with that being said, you guys, tomorrow, live mini read. So if you do want a live mini read, tomorrow morning, 11:30 a.m. Eastern, I will be doing live mini reads. Come on in, come and get your very own mini read. That's tomorrow morning, 11:30 a.m. Eastern. And I will see you guys then. Close it out like we always do. Please take care of yourselves. Please stay safe. Always be aware of your surroundings. I love you guys to the moon and back. Bye-bye for now.